Justice Chavan, the chair of this meeting, Justice Shah, Justice Gupta, Raju Ramachandran, and Siddharth Luthra, and students and professors of this university. First of all, since I'm a member of parliament, I can say I'm a lawmaker. I'm not a lawyer in the standard sense of the term, but I learned law the hard way because my wife is a lawyer and we have been married for 51 years, and I've argued with her practically every day. And in the process, I learned law and started arguing myself. I was also law minister, and therefore I've experienced from different points of view. First of all, I'd like to say that I am in agreement with Justice Shah on the question of eliminating this section, but from a different route, not from the route he has gone, but by a different route, and I'll explain it. In great detail, I have put it in a paper which I've handed over to the chairman of the Law Commission, Justice Chavan, and anyone who wants it can send me an email. In fact, for preparation, one of your students was interning with me, Ashutosh Pandey, I think he's here, so you can get it from him. And the other student who interned with me is also here, Rahul Machavar. So both of them helped me to put it together, and so the detailed arguments are in the paper. I won't take up too much of your time, but to say that this is a great profession, and this profession got us the freedom that we won from the British by sending them home, and most of the people who participated were lawyers. Then we had a state of emergency in 1975-77, and but for lawyers, we would have had a very hard time. In fact, at that time, the government even said that your life can be taken away without recourse to the Constitution. And it was finally the lawyers who fought and finally got us some relief, and with that, we were able to fight against the emergency and overthrow it. Now, there are lots of laws which need to be scrapped in the IPC. Certainly, defamation is one. I tried very hard to have the defamation law decriminalized, but the Supreme Court, a bench of 2 judges didn't agree. But I'm finding some other way to go back to the Supreme Court. I hope the Law Commission will also, and you are taking it up, well, and therefore I'm sure that in this, sooner or later, this will happen, the decriminalization of the law of defamation. You'll be surprised that the argument of the government of which I am as a member of the ruling party very much associated, the Attorney General argued on how beautifully the law was drafted by the British. Forgot to mention that the British themselves have scrapped that law, and it's no more on the books. British have effectively decriminalized defamation law. This IPC, which has the sedition law, it has the hate speech laws, defamation laws, as Justice Shah very correctly said, was introduced in a totally different climate. And it ought to have been tested comprehensively for the constitutionality after 1950. In fact, the Constitution itself had quite a liberal interpretation of the freedom of speech. It was Jawaharlal Nehru who brought the First Amendment, quite irritated that people were saying things against the state, and particularly the Ramesh Thapar case, which agitated him a lot, and it was at his instance. At that time, the only effective speaker against Jawaharlal Nehru in Parliament was Shama Prasad Mukherjee, but he was in terrible minority, and ultimately the First Amendment came, which brought in these extra, including public order, which enabled laws like sedition and defamation and hate speech laws to be part of the book on the grounds that is part of the reasonable restrictions. So I will say that we have at some stage, for example, the CRPC, that was a British CRPC, but we comprehensively reviewed it and brought in an entirely new CRPC in keeping with the democratic principles in 1973. The same thing needs to be done with this 1860 code of the Indian Penal Code. So when it comes to the question of the constitutionality, as Justice Shah has explained, the judgments that are there are after reading it down. After reading it down, they have declared this 124A as constitutional. But it needs to be re-looked at from a totally different perspective, and that's the perspective I want to present here. And that is that when you look at the Indian Penal Code and you look at the sections 121 to 123, 121, 122, 23, these are, in my opinion, all that you need for sedition. The 121 says, it's under the chapter 6 of offenses against the state. Waging or attempting to wage war or abetting waging of war against the government of India. This can be treated as a part of sedition. Similarly, 121A, conspiracy to commit offenses punishable under section 121. That is also okay. 122 says, collecting arms, etc., with the intention of waging war against the government of India. And 123 says, concealing with intent to facilitate the design to wage war. In my opinion, there is no sedition unless you are actually in a preparing or inciting or promoting the overthrow of the government by violent means. That, in my opinion, is the only thing that should be part of the books. Anything which says a speech and so on should not be considered as a constitutionally valid concept of sedition. So therefore, even if you were to delete 124A completely, you will still have sufficient protection for maintaining a government formed by law, and that any lawless, serious lawless attempts to bring that government down, we have provisions in it. I would also like to point out that in the case of, in the Constitution, while secession is not a word that occurs in it, and rightly so, there are articles which more or less make it clear that if you talk about dividing the country or disintegrating the country or giving away Kashmir, as recently people were arguing in Jawaharlal University. I don't mind giving away Jawaharlal Nehru University, but not Kashmir is out of the question. Why? Because Article 1 and Article 2 of the Constitution makes it clear that you can add to India, but you cannot subtract from India. So therefore, there is no provision by which any part of India can be given away. In fact, we had a lot of trouble with this Berubiri Bangladesh matter, and finally it got resolved. But the fact of the matter is that the Supreme Court has been very, very clear that when it comes to any part of India being taken out, they will strike it down. And therefore, one of the aspects of sedition, where people talk about Azadi for Kashmir or something like that, that is clearly unconstitutional. And we can have some kind of a lighter law where we can prohibit such kind of speeches. Similarly, if you look at Article 352 of the Constitution, and I think I'd like to read it, which has been amended during the Janata period to say that emergency can only be declared if there's an armed rebellion. And that Article 352 reads as follows. The 353 in particular, the effect of proclamation of the emergency. While a proclamation of the emergency is in operation, then notwithstanding anything in this Constitution, the executive power of the Union shall extend to giving directions to any state as to the manner in which the executive power thereof is to be exercised. Now, therefore, even in such a situation, if there is a serious situation where there is an armed rebellion causing danger to the unity of India, there is power in the Constitution to give carte blanche to the executive to take necessary steps. So therefore, I would say, first of all, that Article 124, Section 124A should be deleted. And that's because, in my opinion, it has no place. There's no need for it. We have enough laws where if there is a serious case of sedition, we don't have to go into the question whether there was an intention or not an intention. There has to be only an act of war or a conspiracy to commit war. Then only you should consider the question of sedition. So finally, I would say that Justice Shah made a passing reference to the Shreya Singhal judgment. Now, the Shreya Singhal judgment makes three clear distinctions. And that's very important and can be applied, although it's applied for internet defamation, it is actually applicable for hate speeches. It's applicable practically for anywhere where the freedom of speech is likely to be restricted unreasonably. This, Justice Rohinton Nariman, writing the judgment, said there are three stages. Stage one of discussion. That is not, it will be unconstitutional to penalize that. Two, the stage two, which he says is advocacy. You can advocate even you can advocate saying that maybe our country is too big, or it should be bigger, or it should be smaller, whatever. But advocacy by itself, supposing in a university seminar I speak and make a point, that would not come within the mischief of the law. So this is the second thing. And then the third thing is the present and imminent danger caused by what you say. That is the key thing that we have to look. Supposing I am in a theater and the cinema is going on, and in the darkness I get up and say, fire, fire, run. Now obviously there is a clear incitement there for public disorder. You can see that people will get up, start running, trample over each other, some may die. So that kind of present and imminent danger, which was first used in the American law, and it has now been picked up by our Supreme Court. This judgment is a landmark judgment which now should be extended to all the laws which put restrictions on your freedom of speech in the Indian Penal Code, till, of course, one day we have a new Indian Penal Code which is in complete consonance and synchronized with the Constitution of India. And therefore, I think this is an extremely important subject, and I don't think that people, just because they say something which you find offending your patriotism or nationalism, should be penalized under the sedition law. And the examples given to Justice Shah are stark, and in fact, during the British time, they used it quite extensively. It's the same British law which was incorporated in the Indian Penal Code in 1898, which now still in the same wording exists in our law books, and it is time that we get it removed. I will certainly be moving a private member's bill in Parliament and try to get it deleted as soon as I can. And therefore, preparing for this conference or this symposium helped me to clear my mind, for which I have to thank Justice Chauhan. And I also fondly recall that I would have never been able to save Ram Setu but for Justice Shah in Madras High Court. Thank you very much.